humanitarian tragedies on the countries that were targeted. So the transformation from these comprehensive state sanctions to a specifically designed targeted sanctions, some say smart sanctions, some say intellectual sanctions, against individuals, either those who have important state functions or private individuals. Now you all, I'm sure, heard of a Saudi citizen, Mr. Qadi, who I think after 11-ish years of his fight managed to get delisted from the UN blacklist and the EU blacklist. He's one of the examples that all commentators of international and EU law, in a way, now I'm being a bit sarcastic, has to be thankful to, because his experience and his story resulted in numerous literature, in numerous articles, questions, research topics. So in this presentation, I don't want to touch upon Qadi. He's merely an example to be shown of what could be the consequences of using restrictive measures against an individual cause. The sanctioned person is stigmatized, his financial assets are frozen, it cannot get hold of another financial means, there are social consequences, his reputation is ruined, perhaps he has no longer friends, or those who stick with them got stigmatized as well. So it's quite drastic consequences for an individual. Now, the use of sanctions, so restrictive measures, or the goal the European Union is pursuing when using restrictive measures, justify extraordinary fundamental rights restrictions. It is argued. Because they are based on international cooperation or because they form part of a fight against terrorism, this was the Qadi case, or fight for democracy against human rights abuses, and so on. In the search of this equilibrium between, on one hand, fight against terrorism, fight for democracy, fight against human rights abuses, whatever the goal is, and on the other, protection of fundamental rights, is a very difficult task to conceive. Now, I also can put on both sides two sentences. On one side, sanctions are good business, because in fact, in reality, political reality, that is so for some states, for some individuals. And then on the other side, the sentence that we live in an era of human rights. So talk about human rights, discuss its protection, its respect, is more and more fashionable. States apart, again, from the powerful one or those that have some sort of weapons, dangerous tools as nuclear weapons, the majority of the states are judged by their respect of and promotion of the human rights or fundamental rights. So how to put this in balance? Now, the Council of the European Union adopted in 2004 a fairly important document, Basic Principles on the Use of Restrictive Measures. By then, it was obvious that the use of restrictive measures has shortcomings. These documents define restrictive measures as tools the EU member states use in order to uphold respect for human rights, for democracy, rule of law, and good governance. The European Commission publishes regularly an update of all the restrictive measures the European Union adopts. And it uses, in the introduction, these sentences with, I think, immense easiness. Sanctions are an instrument of a diplomatic or economic nature which seek to bring about a change in activities or policies such as violations of international law or human rights, or policies that do not respect the rule of law or democratic principles. These are the goals the European Union is striving for. Needless to say that when one speaks about these respected and well-known principles, in order to avoid the double standard critique, it has to live in accordance to these principles itself. Now let us turn to the general principles. I will start here in international law. Back in 1990s, there was a lot of discussions about the limits that the Security Council of the United Nations might have, or if any, what such limits are. Jill wrote an important article on legal and political limitations, and he stressed the limitations imposed by the purposes and principles of the UN Charter are those that even the Security Council should follow. The gist being that no institution, no international organization, no state can do whatever it pleases. There are limits, and I believe that in this case of the EU, Article 21 of the Treaty of the European Union is crucial. In this article, member states confirm that the Union's action on the international scene shall be guided by democracy, rule of law, universality and indivisibility of human rights, respect for human dignity, principles of equality, solidarity, and respect for the principles of the UN Charter and international law. Now, following are some of the principles that should guide the use of restrictive measures. The principle of democracy, democratic legitimacy, to be in line with my colleagues on this panel. Let us first look at the normative frame. The Lisbon Treaty did improve, to an extent, the area of the restrictive measures. However, it allows the adoption of the so-called smart sanctions in the fight against terrorism, possibly under two legal bases: within the area of freedom, justice and security, or in the area of the EU's external action. The procedure in both cases are different. The European Parliament is only informed when the Council adopts restrictive measures under EU external action. A prior common foreign security policy decision adopted by unanimity is required. Whereas in the area of freedom, security and justice, the European Parliament is on equal footing with the Council. So recently, you will know, the European Court of Justice issued a judgment in a dispute between the European Parliament and the Council regarding the proper legal basis of the regulation on restrictive measures against terror suspects connected with Al-Qaeda, Osama bin Laden, and the Taliban. I don't want to go into further detail of this judgment. I will say I agree with the judgment. I agree that the solution that the Court of Justice agreed with the Council and the Commission, that the European Union's external action is the correct legal basis for this regulation. But at least in this area, in the fight against terrorism, there is, to an extent, a doubt which legal basis is correct or which legal basis to use. On the other hand, when the European Union adopts a decision on restrictive measures, such as, I will mention here the case of Belarus, and I will explain later on why I mentioned Belarus. There is no doubt or what the legal basis is. It lies in the Treaty on the European Union. It lies in the Common Foreign Security Policy area, which means that the European Parliament is merely informed about this restrictive measure taken. Not to mention that the Council takes it behind closed doors with, could be argued, somehow doubtful information with different preferences in mind. So I believe this purely intergovernmental method is an obstacle on the way to a more democratic or democratic legitimacy procedure when using the restrictive measures. Next, before mentioning the principle of rule of law, I will say that this principle is often challenged in times of crisis, when preferences are given to concerns of sovereignty, concerns of security. And the September 11 events again proved this. So I will touch upon the principle of sovereign equality. It is enshrined in the UN Charter and it is enshrined in the Treaty on the EU. Article 4 says, the Union shall respect the equality of member states before the treaties. Now I said I will mention the Belarus example. This Belarus case is meaningful. I will not go into details. You know that it's often cited as the last dictatorship in Europe. Sanctions of the European Union, restrictive measures against Belarus, I think they started in 1996 for different reasons. First, because of the amendment of the constitution to extend the presidential term. Then later on, a couple of years ago, with the presidential election, there was suppression of peaceful protesters, numerous arrests, and so on, and the European Union reacted. It reacted by imposing travel bans on certain individuals responsible for these repressions. It introduced arms embargo, a ban on materials that could be used for internal repression, and asset freezing. Now the European Union reacted within the framework of common foreign security policy, seeking to achieve a change in policy, to improve the human rights situation. As Portela argues or points out, this autonomous sanction policy of the EU is not spread across the globe, but it focuses or concentrates on certain geographical areas. Now, smart sanctions approach to Belarus case meant that a number of individuals, including key business figures affiliated with the regime and entities that were controlled by these key business figures, those assets were frozen. And the blacklist of targeted individuals has been continuously extended. Now this is the background. Why I mentioned the Belarus case? Because not a couple of months now, some months at the beginning of the year, there was this news from abroad. The Slovenian foreign minister undermined the EU restrictive measures policy against Belarus. According to the media, and they were provided with this information by European diplomats, Belarus businessmen, was one businessman in particular, was targeted, or the EU member states wanted to target this particular businessman, but Slovenia vetoed. We weren't the only one. Latvia, I think, was also the problematic country. Now Slovenia, or its foreign minister, called for European Union's comprehensive approach to economic sanctions against Belarus. But this episode, and I add, is not the only one. Of course, it's the recent one, and it's the only one, according to my knowledge, that involves Slovenia. But there were also previous episodes with different countries that in different put veto or argued or didn't accept restrictive measures against some individuals, and not only in Belarus case. So this episode to me points out, on one hand, that the principle of sovereign equality exists in theory. In practice, some states try to circumvent it by using different pressures on a particular country, also by using the media. On the other hand, it proves that member states have different political, economical interests. They have an agenda that is ruining the comprehensive approach towards the use of restrictive measures. Neither is good. I believe the way to respect this principle when using the restrictive measures is to agree in advance on certain criteria and minimizing the effect of external influences, pressures, or arbitrary decision making. Now coming and finishing off with the principle of the rule of law, Jeremy Farrell, he published his, hopefully I said his surname correctly, he published his PhD dissertation on the rule of law and UN sanctions. It's a very nice dissertation, very interesting one. And in his book, he mentions sanctions are often applied and modified in an ad hoc and selective manner. Decisions are generally made behind closed doors with little or no public record of the decision-making process. Sanctions tend to have disproportionate effects upon innocent civilian population and third states, and individuals subject to travel bans or assets freezers are regularly denied due process. So the prevention of arbitrary decision-making, the growth of mutual trust among EU member states, and the access of impartial judicial review, I think are necessary when using this tool. I will add two critical steps involved when deciding to use the restrictive measures according to Courtright and Lopez, who also write extensively about this topic. First is the identification of decision-making elite responsible for the objectionable policy in a targeted state. And second, an identification of assets and resources which are valuable. Why is this important in the context of the European Union? And here I touch upon trust. Because the European Union, at least before establishing the European External Action Service, documents, evidence, proofs of someone's terroristic behavior or linkage to the dictatorship or some post were in the hands of diplomacy. In hands of the diplomacy of those countries that actually had embassies in the targeted state. So in the case of Belarus, not all EU member states countries have its premises in Belarus. So the issue of trust, I think, is an important one. The issue of trust of these proofs, evidences of such a behavior, and criteria of identifying these individuals and their assets. I remember looking at WikiLeaks now. We have access in search of the UN sanctions on Iran, and I know there were briefings of US representatives to different states that tried to persuade these different states also into applying and implementing and explaining why these individuals that are blacklisted should be blacklisted. But again, it comes to trust. Do you trust a foreign country with these evidences, with these documents? Is a provider of this evidence a trustworthy person? Does a country has some sort of secret or hidden agenda?
One more minute. Trust me, without any hidden agenda.
Just to finish off, I believe there is not much respect of general principles when using the restrictive measures by member states, as the frequency of the adopted measures proves their widespread use and abuse. So perhaps an end to some of the shortcomings would be with an improved normative framework to begin with. This is my question. Thank you.
Okay, thank you very much. And again, I open the floor for questions.
Naive question. I remember, if I remember correctly, that it started with a sort of a mentioning of the democratic deficit taking those decisions in a sense. But is it wise to let's say, open up the decision making in such cases to a more broader body of deciders? And what's the most pragmatic solution proposal is, or how to balance these tendencies.
You see, there are no naive questions. Of course, a question to the point. Foreign policy issues are normally, even within national states, member states in general, taken behind closed doors with the purpose. However, I think, to some extent, in these cases, the damage caused to certain individuals is the same as damage caused to member states if they open the door and try, but not open the door within the Council, but try to include the European Parliament in the discussion. Perhaps then we would limit or reduce the political differences between states to a minimum and try to put them on a legal perspective. And when there should be a legal criteria for, again, as said, to minimize this external foreign influences, political, economical, and so on, perhaps we would have those individuals put down against whom really restrictive measures should be taken. I think it's the human commission case. There was an American judge who gave an opinion dissenting, and she said, well, we talk about sanctions, we talk about restrictive measures, but does no one think about people who got killed? You know, as a put things into perspective. Yes, we ought to. That's why I'm saying the adoption of the restrictive measures is in order, is justified, but not in any case, and not for any fundamental rights abuse. So I think the opening the door, not of the Council perhaps, but including the European Parliament, perhaps, I'm not a fortune teller, might reduce the possibility of putting on blacklist an individual which has nothing to do with it, but whose life changes dramatically because of this blacklisting. And this was probably you will know the European Court of Human Rights case of Nada, who is an old, elderly Italian citizen. Italian. I think he also had Egyptian citizenship. He lives in this small enclave or exclave Italian, Campione d'Italia. It's surrounded by Swiss, and he because this is a small place where I heard those who like to gamble goes. The taxes are low. Perhaps you will know more about it than me. But he, not because of that. You need to explain. You need to explain.
But you should explain.
No. Explain. But he. This is now. I'm researching gambling. That's why she said no. He's an elder man now. I think he's 70, 80. He was blacklisted by the United Nations Sanctions Committee. He has been living in this exclave for many years, not just because of the tax benefits. And they realized that his human rights, his fundamental rights were breached by blacklisting him. So I think these kind of extreme cases perhaps justify opening the door to a more democratic input in these cases.
All right.
I'm saying that's the best solution.
All right. I have a question for you, but I will save it for later on because gentlemen says just wait.
Can I ask?
If it's a short one, because we're slowly. Okay. Yeah, please.
Just like I wonder, at your understanding, the situation in Syria, are sanctions and restrictive measures for fundamental rights abuse in Syria adopted in justified or ad hoc and selective manner?
I don't think it's a straightforward answer. Because also in Syria, I know people, I think they have targeted sanctions as well, not only arms embargo and so on. I don't think it's a straight, neither of these cases is straightforward. I think, again, the method of approaching the restrictive measures use is important, because then we could answer these questions. Going from one method, from one restrictive measure to another, from one name on blacklist to another.
Okay. Do the other members of the panel, would you like to say something else? Yeah. I mean, you should explain your gambling background. I mean, if you're researching gambling, you should know something from practice.
Later we have some time. Other places.
You can go to Hit in Kranjska Gora.
Okay, so then thank you very much for your very nice presentations, comments, and thanks.
Thank you.
Now,
Okay. So moving from the EU-related business back to the legal theory and philosophy, we have one last speaker before a well-deserved dinner. It's my pleasure and honor to first greet Luka and to announce it as the next speaker. Luka from Zagreb, Croatia. The title is "The Concept of Law as an Artifact Concept." Please, you have 20 minutes.
Thank you. Thank you. First of all, I want to apologize myself for coming so late to the conference because of several important reasons. The apology goes, but I won't mention them. The apology goes both to
more compelling reason than being here.
the apology goes both to the organizers as well as to the presenters in the morning sessions. Before I start my presentation, I would like to give make just two remarks. First, I've only recently started to deal with this topic, so these are just my first basic ideas on the issue, and I will welcome your comments after the presentation, so that I can improve my thoughts. And the second remark is that Brian Leiter, in his most recent article, The Demarcation Problem in Jurisprudence, said that he's surprised because many of the contemporary legal theorists don't accept the fact that law is an artifact, and he says that he will not spend any time on them, but their problem is not for philosophy but for psychiatry. So that's why I started dealing with this topic. Well, let me start. I will be in those 20 minutes framework. The concept of law as an artifact concept. Law is often analyzed in the concept monism fashion, so the concept monism claim, by decomposing it into its essential or necessary features, the decompositional claim, and in line with its assumed hermeneutic nature that calls for an investigation into our law talk with the aim of determining the concept of law, so the hermeneutic claim. In this paper, I will propose an alternative only to the second and third claim, decomposition and hermeneutic claims, and leave a more detailed critique of the concept monism claim to be discussed in a subsequent paper. Assuming that the concept of law is determined by more than a mere understanding of those subject to law, consideration should be given to whether the concept of law is exclusively a hermeneutic concept, or whether it would be more fruitful to explain law as a human artifact, based on the general theory of artifacts, and thus also the concept of law as an artifact concept, determined not only on the basis of how its addressees understand it, but also on the basis of the intentions of lawmakers. Finally, if, taking into account the fact that the concept monism of today has failed to produce any adequate results, one were to accept that the concept of law should be analyzed as an artifact concept, one would have to consider the possibility of accepting concept pluralism with respect to the concept of law, following the example of new tendencies in the philosophy of art. This would create an environment which would open up new lines of inquiry for legal theory and would allow for a more fecund reappraisal of the existing conceptions of law. The paper, however, only aims to outline some preliminary thoughts on how one might analyze the concept of law